Hey, hello everyone, and welcome to another installment of our show, The Docket. As many of you know, and for those of you who don't, the docket deals with legal issues and entities that affect you and our community. We try to present these things in both an understandable and enjoyable way. So thanks for joining us, and we certainly welcome any feedback or suggestions that you might have. We'll be right back with today's guests, and it's going to be a very, very interesting show. Our guests today are Edythe Payan and Bridget Sakells, and they both work for the State Public Defender's Office here in El Paso. And before I forget, let me reintroduce myself. I don't know, some of you may not even know who I am. My name is Bob Warwick. Edythe has been in the Public Defender's Office for 21 years. Bridget has been there for quite a long time also. And before the show, I generally get together with the guests and get some information. So Edythe is the public defender, an attorney. Bridget is what is called a mitigator. And what we're going to talk about today is the death penalty. And something I didn't know, and I learned, is that every capital murder case is assigned not only an attorney, but also a mitigator. And then there's some other people on the staff. So today we have the attorney and the mitigator. And we're going to, it's an emotional topic, certainly. And the example I had used when we were first talking about this is it's not like Frankenstein, where the townspeople go out with pitchforks and try and poke them. This is a very, very protective process because it's a very, very important issue. We're talking about whether or not to take somebody's life. So let me get the burden off of me and put it on my guests. And we'll start, I think, first with Edythe. Give us, and something I didn't know, you explained to me, there's a capital murder charge that may or may not involve a death penalty.
So in order for a case to even be a death penalty case, it first has to be a capital murder. And all of this obviously is regulated by the Texas Penal Code.
Can you briefly, and if you can't tell me, give us the elements of a capital murder charge?
So capital murder charge, first you have to intentionally and knowingly cause the death of someone, and then there are aggravating factors. So for example, you would have to intentionally knowingly cause the death of two people, or intentionally knowingly cause the death while you are intentionally knowingly committing an aggravated robbery, or you intentionally knowingly caused the death of a police officer and you knew he was a police officer. So there are several, and that's all in the Texas Penal Code. So once an offense is a capital murder, not all capital murder cases are going to be death penalty cases.
Okay, and can you just, again, tell us the difference?
Yes, so under the law and the Texas statutes, it's the district attorney's office of each district attorney's jurisdiction in the state of Texas. The district attorney gets to decide, he or she. And so depending on the office, depending on what criteria or how they've established their protocols, but elected district attorneys have the discretion to choose whether or not to seek the death penalty on a capital murder case.
So if a district attorney tells his staff, we're going after this person, and we're going to try this person with the penalty of being a death penalty case, it could still wind up where the death penalty is not the result of the verdict, but it could be life in prison with no parole. Is that right?
Yes.
Okay. And so explain this, the no parole. I think that's important for the public to know.
So yes, once the district attorney decides if they're going to seek death, they have to file notice of the death penalty. Then they give it to the defense. But there would...
That's you.
Right. That would be, yes. But there is a trial, or it could be also a plea agreement. But there was a time previously to 2001 where life without parole, people were still getting paroled. The Texas legislature changed that statute. So now if someone is sentenced to life without parole on a capital murder, it truly is a sentence in the Texas Department of Criminal Justice without parole.
You're not getting out of jail.
You're not getting out of prison.
Prison, right.
So, right, jails
It's
downtown.
local, yeah.
Yes, you're not getting out of prison.
So, and again, correct me if I'm wrong. So there could be three results if somebody brings a capital murder, if the DA brings a capital murder charge. It could be a death penalty case. Mm-hmm. It could be life in prison without parole, or it could be not guilty.
Yes.
Is that right?
For the most part, yes.
Yeah. Well, and so you say for the most part. Is there something else there?
There are times maybe the DA would have started off with the death penalty case, and over the course of negotiation, you could plea it to life without parole, or you might plea it to a murder. That gets a little too much in the weeds.
In the weeds, okay. Yes. But the murder could, just so I have it straight in my mind, if it pleads down to murder, then possibly you could go to prison, but it wouldn't be without parole.
Right.
Okay. So, Bridget, let me just go over to you for a minute. You're what's called a mitigator, correct? Your background is social work.
Yes.
You are involved in every capital murder case, is that right?
Right. There's one of us assigned to every capital murder.
All right. And do you always work with the same attorney, or do you work with different attorneys?
No, they're always different.
Okay. What is your job?
My job is to humanize the client and to allow the attorney to present their life story if we go to trial, or to use that information in negotiations with the district attorney's office.
So you're looking for, and let me also say, this discussion today is not pro or anti death penalty. I've explained that your office defends it, but that's not what we're talking about today, whether you're for it or against it. What we're talking about today is the process and the fact that it's a lot more complicated than most people think. So you are looking for mitigating circumstances so that when Edythe goes to trial, she has those and can talk to the jury about it.
Correct.
Okay. What are some of the mitigating circumstances that you would consider important for her to present to a jury?
So depending on the case, we look a lot into people's history and what they've experienced in their life that brought them to the point of being accused of this crime. And everybody has a life story, and some people's just seem to be a little bit more intense than others. And there's always reasons, if we dig hard enough, that get us to why we're sitting here today. So it can be anything from childhood abuse to, we get a lot of people who've been in the military with PTSD, all kinds of different situations that we uncover during our life investigation.
And to be clear, this isn't an excuse.
No.
These are just reasons that this particular defendant has gotten to this point.
Correct.
Is that right?
That's right.
And so if you, and I'm still trying to get this clear because it's not easy. And let me also do an aside. Not everybody can defend a death penalty case. Is that right?
Correct.
All right. What do you have to do to be able to defend it?
So you have to be qualified to represent a defendant for a death penalty case. The statute set out the qualifications, and here in Texas, there are different administrative judges that you have to apply. You have to have experience. You have to have a number of jury trials. You have to have a certain number of jury trials as a first chair. To be a first chair defense attorney for a death penalty case, you would have had to have what we call second chair,
right,
worked on another death penalty case. You have to have maintain a certain number of CLEs, continuing legal education hours, specifically in capital work. So there are criteria established.
And so you are one of the people that are certified to defend death penalty cases.
Yes, I'm one of
in the state of Texas.
In the state of Texas and in El Paso.
And about how many are there in El Paso?
So El Paso, we are part of the 6th administrative region, which goes as far as Kerrville, Texas.
Goes all the way down to Kerrville?
It's an odd region. And so in addition to some people in my office, I think there on that list, there's maybe about 15 people that I know of that are qualified to represent someone on death penalty as a first chair.
That could do that in this district?
Mm-hmm. Yes, sir.
Do you have any idea how many are certified in the state?
I don't, because I'm not even sure. I've never seen the other lists, so
Right.
I really don't know.
So now combining what Bridget does with what you do, so a death penalty, and I'm asking these questions really to try and get it straight in my mind so the people who are watching can get an idea of what everybody has to go through. So a capital murder case is brought, the DA decides to go for the death penalty. You take the information that Bridget has and include it in your defense. And what you're trying to do, I suppose, is bring it down to, rather than a verdict affirming a death penalty, life in prison without parole, or again, not guilty. Is that right?
Right. So step one in a death penalty case is like any jury trial in Texas. That's bifurcated. So part one is
and bifurcated means you have the guilt and then you have the
Correct.
sentencing.
Right.
Okay.
One is if it's a person guilty or not guilty, and if they're found guilty, then you have what we call the punishment sentencing. So a death penalty is the same. Obviously, the issues are more complicated. So depending on the state's case, the defense's theory, some of the mitigating information may be admissible at the guilt stage. But if the jury finds that the defendant is guilty beyond a reasonable doubt of this capital murder offense, and it's a death penalty case, then we have part two. So it's a completely different set of facts, and that's where all of the hard work that Bridget has put in really is vital. If it's testimony, I mean, it's her work then comes to life. We have witnesses, family members, sometimes records that we are going to admit in front of the jury so they understand this person's life story.
When you're trying, Bridget, when you're trying to get this information, what are a lot of the responses? Are people mostly willing to talk to you? Do some not want to talk to you? Some wash their hands of this person?
It's a mix, but there are a lot of people who don't want to be involved. Generally, they will talk to us, but they want to make sure that they're not going to be called as a witness. They'll give us information, but they don't want to be overly involved. Family members tend to be pretty helpful most of the time.
I would think, unless you're trying to base some of the defense on child abuse.
It gets a little tricky.
Yeah, I imagine.
Yeah.
And do you talk to teachers, doctors? I mean,
we talk to anybody who's had contact with the person in their lifetime. So we do go back and talk to teachers. We talk to medical professionals that have evaluated the person. We do, time with religious entities that they've been involved with, if they've had that experience, just anybody who's had contact with them.
and then all that information again goes to Edythe, so
Right.
and she's able to use that in the punishment stage, correct?
Right. And I think I want to highlight something else that the mitigation specialist will do is there are times we may need to work with our own experts. We may need our client evaluated. Obviously, mental health issues are unfortunately very common in these cases. Bridget will identify what she sees are some issues that we may need to develop, do our own testing at times. So yes, and as a reminder, it's not just me. We will always have 2 attorneys on a death penalty case,
Right.
at least 2. You have to have 2.
It's like having 2 pilots in the airplane.
Yes, yes, yeah.
And this is not a loaded question. I just thought of it, and actually lawyers are never supposed to ask questions they don't know the answer to, but I don't. Have you ever been involved in a capital murder case where the person was found not guilty?
No.
Okay. And see, I asked that question, now I forgot the next one. But I know we're going into the weeds a little bit here, but in the punishment stage, can you explain what the burden the jury has at that point? How they move forward to come to a result?
So technically, the burden is on the state of Texas, and the burden is on the prosecutor. And at that point, the prosecution the jury will have to answer several questions at the punishment stage. One, then this is only in a death penalty case. The jury will have to answer if the defendant is going to be a future danger, if there is a probability that they will continue to commit crimes of violence in society. And so the state of Texas, the prosecution has to bring that evidence for the jury to be able to answer that question beyond a reasonable doubt. If the jury believes that, yes, the defendant is a continuing danger in society, and society includes prison, because at this point, this person will be in prison for the rest of their lives. If that answer is yes, then there's that second phase, which is the mitigation phase. And at that point, then the jury will decide, is there anything that will mitigate this defendant's moral blameworthiness? If it's their upbringing, their mental health issues, whatever it may be. If a jury believes that, yes, there is something to mitigate their life or what happened, then it will result in life without parole. If the jury says, no, we don't see how any of this information in any way could mitigate what happened, then that would result in a death penalty.
And you always hear or read about somebody's been on death row for 20 years. How does that happen? What is happening once they're found guilty, the death penalty has been assessed, now they're in prison waiting for that to happen? But why the length of time?
Because there will be an appeal.
Because there has to be an appeal, correct?
There has to be an appeal. In a death penalty case, the defendant cannot give up their right to appeal even if they wanted to. The appellate process is a little bit different. You go directly to the Court of Criminal Appeals. You bypass the Court of Appeals. And then depending on what happens there's writs. There are federal writs. You could end up in the Fifth Circuit. Yes, they can take a very long time.
Do many of these people on death row die before their case is resolved? Does that, I don't know if you know that, but it just seems like they stay there so long.
I don't know of since I've been doing this kind of work in the El Paso community, I do believe there was one defendant that's passed away. It wasn't a case
that you
tried,
did. Okay.
But, mm-hmm.
How many states have done away with the death penalty? Do you know that?
You know, I really am not even sure.
Okay, but some have. I think some have. Have they not?
They definitely have. I think I would be hopeful, but since we live in Texas,
right,
I don't see.
Yes. And don't forget, we're not saying pro or con.
Right,
this is just the process. But I mean, everybody who's watching this is going to know your job is to defend the person. We know how you feel, but I don't particularly want to get in that discussion today. It's a situation I was very naive about before I talked to you guys. I mean, I was one of those people holding the pitchfork when I would read about what these people were charged with doing. And a lot of what you're talking to me about now made me rethink how I have to feel about this. But do you ever use, and I think this is kind of a legal conundrum, but I don't know again, do you ever use they were mentally ill when they committed the crime as a defense?
Yes, but that's also its own set of legal issues.
Because you have to be competent
Correct.
to stand trial.
Right, and there's also the insanity defense, which there are cases that the insanity defense is very technical. So yes, that is a defense that is used.
But if you use an insanity defense, and I'm assuming your mitigation investigation would have a lot to do with that, yes?
Correct.
That simply delays the ultimate outcome, doesn't it?
I don't know if it would delay the ultimate outcome. Remember, if you're at trial, like you said, it's because the person is competent. They're able to understand. They can talk to you about their case. They have a rational understanding of the facts of the system. An insanity defense doesn't necessarily delay it any more than the length of time a case like this would take.
How long does it take to get a death penalty case to trial?
Now, since, as we were talking about earlier, with COVID being a factor, I don't know how long it would take. Typically, they would take about 2 to 3 years to actually end up before a jury where you're picking a jury for a death penalty trial.
And these people stay in jail, is that right?
Yes.
Pending
Yes.
the trial.
For several reasons. Some of them, there is a no bond set. On some of them, there would have been a bond hearing, but the bond is so egregiously high that they can't post bail.
And why would a prosecutor, be it a federal prosecutor or a state prosecutor, why would they not choose to prosecute the death penalty? What would be the reasons?
The mitigating factors, depending on what information they may have based on their investigation, depending on what information they receive from the defense. As Bridget said, a lot of what we do, and not just in the death penalty cases, all our cases, is we try to get this information to the prosecutors before to show this is our client's life, this is what we have, please, withdraw the death penalty. And so that's also a reason. They might also reassess their case. I mean, this is obviously a huge burden on the state. It's expensive, it takes time, and that's a factor that I think they often consider as well.
Bridget, in the federal system, do they also have mitigators with every death penalty case?
Yes.
Or capital murder case, rather?
Yes.
Do you have to have a special certification to do the mitigation, or you do this basically on your experience and the fact that you're a social worker and that sort of thing?
Right. So the ABA does have guidelines for mitigation specialists, and it's just the number of years that you've been involved in cases like this, and your education. There's different things that they take into consideration for the people that are qualified.
And how did you decide to do this? I mean, most social workers I know are trying to find someplace somebody can live.
She does that too.
I didn't choose this. It chose me.
In what way?
I came into this work kind of accidentally, but it ended up being a good fit. So
that's always nice when that happens. And getting back now again to Edythe, this has got to be, what you do, so incredibly stressful. Somebody's life is on the line. What do you do to keep yourself sane?
I think that implies I'm sane. So people, it's hard when you're working on these cases, especially when you're trying them. Once you get started, They can take anywhere from 3 to 5 months. So I think that goes back to, what do they call it now? Work-life balance?
Right.
Which, yes.
I mean, really, I don't know that I could do something like this, honestly. The pressure. And there's another question I would have. Do a lot of these people just say, I didn't do it? That pressure would be terrible if somebody, their life was hanging in the balance on what I was doing for them.
Well, on some of these cases, it's a regular trial. I mean, you're litigating the guilt because there is a defense. And yes, that happens too.
Oh my God.
Mm-hmm.
And how long have you been doing this?
So like we said, I started the public defender's office 2002. I started doing capital cases 2007, 2006, 2007 is when I first started working on these types of cases.
Well, I think that now we've given everybody a broad idea of what you guys have to do in your jobs. Maybe I think we should have another show and then really get into the weeds of the technicalities. I mean, there's nothing more important than somebody's life, and there's nothing more important than making the right decisions. And we see today, I mean, how science has progressed, where people have been in jail forever, and then based on DNA findings, they never should have been. And I know, again, we're not for or against the death penalty right now, but you know, can you imagine you killed the wrong person? That's why there's so many protections here. So
I was just going to say, I don't know how much, but there is, when you asked how long some of these cases take, there is a death penalty case that has been going on for a long time, and it is because of new DNA evidence and new science that gave them the opportunity for new hearings.
Yeah, I wouldn't even want to be on a jury for that.
And we do need to talk more about the jury.
Yeah, I mean, the next time we will. I mean, you showed me what the jury is asked, and I said to you, this is so intrusive, and you said, yes, it is, but we're talking about somebody's life, and we're out of time. So I told you this would go quickly. I really would like to do it again. We'll talk about what a jury has to go through. We'll talk about those couple of questions that have to be answered, how they have to be answered, and how important it is that the law be followed here. So we're just not paying attention to it. It's important. Thank you both, guys. I look forward to having you.
Thank you for this opportunity.
It was great. And the other day I did a shout out. I want to do a shout out, though, for everybody who makes this show possible. They make me look good, which is very hard. It's not so hard to make you look good. But we have, let's see, Jaime and Patrick and Carol and Marco and Debbie, and I'm sure there are people I forgot, but I want to give them a shout out. Thank you, everyone, for showing up today. Thank you, everyone, for watching today. We look forward to seeing you in the next show.